Good evening, everybody, and welcome to our nightly roundtable, our nightly legal roundtable, the seventh day of testimony in the impeachment trial for Texas Attorney General Ken Paxton. And I think it could certainly be stated that this has been one of the most interesting days, if not the most interesting day so far. I want to introduce you to our panel tonight and thank them each for joining us. Jorge Vela, Marc Chavez, and Thomas Just, each of them esteemed attorneys here in Austin and Travis County. Where to begin? I'll tell you exactly where I think I want to start, and that is first thing this morning, everyone sat on the edge of their seats after it was stated that Laura Olson, Ken Paxton's mistress, was going to be called to the stand. And then there was this conversation about a lack of proper notice to the other side, where there was a requirement that they receive 24-hour notice. And then she was going to testify this afternoon, but when she was called, the lieutenant governor, the presiding officer, made a statement that she had been deemed unavailable to testify. Jorge, I'll start with you. What in the world do you make of that?
Well, Tony, thanks for having me on this evening. I appreciate being here. And like you said, exciting day, but so anticlimactic. I mean, the entire time we're waiting to hear from perhaps the most, sensational, exciting witness in this entire process, only to hear just a quick little dismissive snippet from Lieutenant Governor Dan Patrick that she was available, that she was present, but she has been deemed unavailable as a witness. Now, as a defense attorney and a former prosecutor, the first thing that comes to my mind is that she invoked her right against self-incrimination.
Her Fifth Amendment right.
Correct. Her Fifth Amendment right against self-incrimination, fearing that through her testimony, she may say something that may actually incriminate herself. And so it's a privilege that she can invoke to protect herself in this case. Now, as a former prosecutor, I can tell you, if this were a criminal case and I thought that her testimony was as important as everyone thinks it is, then my first inclination as a prosecutor is to offer some kind of immunity. There's different types of immunity that a prosecutor can offer, to transactional immunity, complete immunity. And so the interesting thing in this case is that we're not in a criminal courtroom. They're not actual prosecutors. And so, the authority for them to potentially offer her some type of immunity, I don't think
they don't have that advantage.
Right. I don't think that applies here. And if you do, as a prosecutor, I will say, if you offer a witness immunity, then they can be compelled to testify. And so I don't think that option was available to the prosecutors in this case. Now, there wasn't much discussion on the record, and so we can only assume or guess. And as an experienced trial attorney, that was the first thing that rang in my mind. I don't know what other attorneys think here.
And I do want to say, Jorge, based on our reporting, she did, in fact, plan to invoke her Fifth Amendment right. Thomas, I want to ask you, given that, is there any advantage for the prosecution to literally call her to the stand, to have her say out of her own mouth, I'm invoking my Fifth Amendment right?
Yes, because this is not a purely criminal trial. In civil cases, you can call a defendant or a party to the stand. You can ask them those questions, and then they can invoke their Fifth Amendment rights, not to self-incriminate. But in a civil case, the jury gets to draw negative inferences from that, whereas in a criminal case, you cannot. And so it would have been helpful for the prosecution to put her on the stand and go through and ask her the series of questions that they wanted to, and have her go through the motions of pleading the Fifth, and then allow through that questioning to try and tell a story and get across their point to the jurors, essentially saying, had she answered this question, it would have been the worst possible way to answer this question. It would have potentially incriminated her. And so that is definitely something that is big win for the defense team to be able to prevent that from going forward at all.
Yeah, Marc,
jurors
Marc,
can really be impacted.
Marc, the lieutenant governor said that this was an agreement reached by both parties to dismiss her. What do you make of that? I mean, especially given what Thomas just said, which is that the big win for the defense and a big loss for the prosecution. Why might they have entered into that agreement?
I mean, obviously, Tony, we're talking about speculation, but the best that I could, glean from what has happened in the last couple of days. One, I completely agree with Thomas that it could benefit because you don't know how those jurors will react to putting her on the stand and her pleading the fifth. That's first. So you always want to do that because, like he said, you can draw negative inferences from that. But if I'm putting myself in the prosecutor's shoes, it is simply this, that they agree to it because they believe through their other witnesses, especially the witnesses yesterday, who recount the fact that he confessed about the affair. They were seen out in public at various places together, that it has cemented the relationship with this lady. They believe that they already have those puzzle pieces in place of that relationship. So putting her on the stand just to say the fifth over and over again might lose focus in that relationship. And they believe that they already have the puzzle pieces. As we always say, Jorge's prosecutor, we always say, you got to put the puzzle piece together to show the picture to the jurors. Now, whether they have these big puzzle pieces that they believe the jurors can fill in the blanks or not, at least maybe they believe that there's already that known relationship that is solidified, that they don't need to put her on the stand to really get no material fact out of her if they know she's going to plead the fifth. So it's a weighing between pleading the fifth and having them draw negative inferences, or the fact they say, we already have that relationship cemented. We don't want to end with kind of a flat affect of her testimony, when originally we kind of believed that this was going to be some type of testimony that was going to set off fireworks.
Particularly revealing and
Exactly.
sort of a mic drop moment for the House. For the House prosecutors. I want to ask Thomas you this, but get everybody's thoughts on it as well. I mean, within the last hour, there was a lot of excitement because the defense, Tony Busby, stood up and said that they were filing a motion to have the case stopped, essentially, because of insufficient evidence. In other words, saying that the House prosecution had not presented sufficient reason for the proceeding to go on. I had a couple of other attorneys on speed dial, and they tell me that that's not that entirely unusual.
No, in fact, it's standard practice. As a defense attorney, anytime the state goes ahead and rests their case, we're going to go ahead and move for a directed verdict. It's interesting because, this case is so much different than an actual normal case. And you've seen that through the confusion over discovery rulings and all the rest of it, evidence rulings rather. There's also no appeal here, right? So one of the important things that all criminal defense attorneys do is they move for that motion for a directed verdict to preserve an issue on appeal. Here you don't have really a possibility of appeal. So, while it's normal, it's worth, and you don't have an appeal issue, it's worth taking a shot, because if you can start and pick off some of those articles now, that narrows the target for the defense to defend.
But Jorge, within the hour or so, the motion was only existent for about an hour before, at the same time, the House prosecution said, by the way, we've got a response already drafted. So clearly they anticipated this, but then both sides within an hour or so agreed to withdraw their motion. So what do you make of that?
I don't know what the reasoning behind that is. I think Thomas hit the nail on the head here. A directed verdict is a standard procedure that every diligent defense attorney must file in any trial. Now, the standard is very low for the prosecution to overcome a directed verdict. It is a standard motion, but it rarely ever is successful. And so that may have come into play here regarding what you just mentioned, that both sides withdrew their motions. Again, when we file a directed verdict as a defense attorney, what we are arguing to the court is that no reasonable jury, like this shouldn't even go to a jury, that no reasonable juror could ever convict our client based on the evidence presented. And so it's a very high standard for us to prove, basically, or to show that the prosecution hasn't even shown sufficient evidence for a reasonable person to even consider that he may be guilty of these offenses. And so that may have come into play because of the extent of evidence that has been admitted. But, I actually we mentioned ending this with a bang. And I have to say, I disagree with Mr. Chavez. I think it would have been extremely powerful to end with the sensational witness getting up there, Miss Olson, and declaring the fifth. Sometimes declaring the fifth, just those few words speaks volumes. It speaks volumes. I think that would have been a mic drop moment. I would have asked her the first 10 questions. She would have invoked the fifth. And to me, that's a mic drop moment because she is basically implying that there is potential criminal conduct that she's aware of or that she took part in with these conversations. And so, I would have argued to throw her up there. And I don't. So, you brought up something interesting that Lieutenant Dan Patrick brought up, and he said that the parties had agreed that Miss Olson was present but unavailable. Now, I don't know if he misstated that because I don't see how the prosecution would have just agreed that she was unavailable. I would have argued as a prosecutor on the record.
Hi, George. I'm putting her. I want to hear her words.
Yeah.
Marc, when we talk about witnesses who potentially move this case forward today, I mean, we didn't hear from Laura Olson, the mistress, but we certainly heard from Andrew Wicker, Ken Paxton's executive aide, the man who kept his calendar, traveled with him. I mean, we are talking about, whatever is even more intimate than sitting at the right hand of Ken Paxton. I mean, right. A very unique relationship that we see some of these elected officials have with someone like an executive aide. Marc, what did you think of his testimony?
Frankly, this is the closest that they came to actually showing quid pro quo. Okay, with the remodeling and the Nate Paul and how much is this going to cost? Well, you got to go ask Nate. And then the defense insinuated about these pictures of the Paxtons shopping to show that they actually paid for their own remodel. This witness, in my opinion, is the closest that they came to actually settling the quid pro quo question that actually then leads into the relationship. And what did Nate Paul do to help out, the attorney general? Because we know what he did, reverse, what was the benefit that he was receiving, the AG, from this gentleman if he helped out, the potential FBI investigation. So Wicker, to me, substance-wise, whether he was, as entertaining as the other witnesses or not, came the closest to providing that information for the jurors to hear.
But I'm curious to ask Thomas this. Thomas, do you think they landed that plane with Andrew Wicker?
I do. I mean, I think this was the most damaging witness, especially when the prosecution was able to successfully lay out the timeline of how those events occurred, and the fact that General Paxton issued that $121,000 check the day after the FBI meeting with the whistleblowers. And in addition, it was before he even gotten an invoice for it. And in addition, it was significantly after it appears the construction had been completed. That's not how any of that normally works if you've ever dealt with contractors. And so, more than anything, I think it calls into question the credibility of, the explanation that's been provided to explain all of these. It kind of begs the question of, do you really expect me to believe that this was all on the up and up? That timeline just is really, really devastating.
Well, and speaking of that timeline, I mean, there was this effort by Team Paxton to demonstrate that this payment was sent to Cupertino Builders, after receiving an invoice for $121,000. But then at the very end, we saw the prosecutor on redirect suggest that metadata showed that this invoice was actually created October 1st, immediately after Ken Paxton was informed that his staff had gone to the FBI. I mean, that seemed like such a critical moment. I want to ask each. It's so critical that I want to ask each of you about. Jorge, I'll start with you.
I think you asked Marc and Thomas about whether Wicker landed the plane, was what you were asking. And one thing I noticed, and I've seen a pattern with a lot of these witnesses, is that Wicker wasn't part of these transactions. I think the powerful part of his testimony wasn't even his own words. It was the documents that they were trying to discuss through Wicker. Same thing with the whistleblowers, right? A lot of it, they were talking, like with Wicker, they were talking about transactions that he had no personal knowledge of, but they were showing text messages that he wasn't a part of. They were asking about bank transactions that he had no personal knowledge of. There was no evidence that he was part of those bank transactions, but they're asking Wicker, his right-hand man, to discuss these things. My objection, if I was Busby, would have been, this individual has no personal knowledge of those transactions. Why are you asking these questions to them? And it's a pattern I saw throughout this trial. And honestly, in a criminal trial, I don't think that would have flown. I think a judge would have said, this individual has nothing to do with these transactions. Why are you asking him about transactions between two third parties? So I thought that was interesting. I don't know if they landed the plane with Wicker, but the documents speak volumes.
Yeah, Marc, do you agree with Jorge's assessment there?
I do agree with what he's talking about as far as personal knowledge and relevance. 1,000% he's correct when it comes to that not being allowable in a criminal trial. To answer your original question about what did that do, the timing of that document, that it happened right after the whistleblower came into effect. And here's how I analogize it as I saw it coming out and heard it today. It's almost the equivalent, Tony, of the defense asking Wheeler early on, why did you send a memo without Ken Paxton's name on it? So there's that big question of, because, the defense's theme early attacking those witnesses were, this was a staged coup. You guys wanted him out and y'all had a plan. And you send a memo without his name on it. Interesting. Well, the the prosecutors through the House did exactly that with their evidence on this invoice dated October, because what that does, not only does it show the timeline that helps out their case, but it asks so many questions out there that the defense now has to answer, whether through the argument or through their witnesses, to say, hold on, after the whistleblower, you still had this invoice? That needs a lot of answering. So that's how I analyze it, is for how much, if you felt like that Ken Paxton memo hurt the House, that hurt the defense equally.
Do you agree with that assessment, Thomas?
I do. And one of the things I wanted to add was, like Jorge was touching on, the evidence issues here have been maddening from the attorney perspective to watch, because, no offense to Dan Patrick, and it's not really his fault, but he didn't go to law school and he's not a judge. And so you have seen repeated issues where the rulings don't make any sense. Right.
Sustained, overruled.
Yeah. And the other issue is that experienced judges know how to get control of their courtroom. They know how to control it. And there's been a lot of bad behavior in terms of sidebars, speaking objections, filibustering. There have been a lot of things that in a normal courtroom you just wouldn't see. You'd see that for maybe about 2 minutes and that'd be over. And so you've seen a lot of those, and from an attorney's perspective, that would make it really, really hard, I think, to prepare to do these directs and crosses, because you're going to have a hard time predicting what's actually going to get in and what's not. And so I think that adds an extra layer of complexity.
One last question. We know that the state, I say the state, the prosecution has now rested. The defense will start tomorrow. One last question for each of you, and Marc, I'll start with you. What does the defense need to do? I mean, certainly we have seen them aggressively cross-examine the prosecution's witnesses, but they've got a moment in time now to seal their case. What do they need to do?
And here's the biggest thing, Tony, is they have to consider whether it's even worth addressing any witnesses of their own. Because there can be something said, kind of like Jorge was talking about the fifth, and there can be that impact that they think of. There could be an impact if they stand up and say, you know what, defense rests, because we believe they didn't even come close to meeting their burden. And that says something in this type of hearing, and maybe not so much in a criminal hearing, but in this type of hearing, it could mean a lot. Now, if they choose to address certain issues, frankly, for me, the one that has the most questions is this invoice that came forward. And also, there was a correlation between these pictures of the Paxtons shopping for remodeling. But I mean, there is that gap between shopping versus actually purchasing. Show me the physical financial records that you were out a lot of money for this remodeling.
Right.
I mean, that would include bank statements.
Doesn't mean I purchased the countertops.
Exactly. Well, and like they were talking about, since we're not really dealing with rules of evidence and who can speak to these financials, they could throw on another person who has no personal knowledge and somehow try to get in the financials of the Paxtons to say, look, we're showing you the financials that they actually paid for it rather than just the pictures. But
I'm sorry, Marc.
I was going to say, they may make a statement by standing up and say, we don't want to use the rest of our time. We rest.
What about it, Jorge?
I agree with everything Marc is saying, but if defense has something, and I was hoping you were going to call me last, because the man who has the last word makes a big impact. Jurors tend to remember, we're talking about two types of jurors here. We're talking about the jurors that are sitting there watching, right? The senators. We're also talking about the public, though. This is a public trial. It's so obvious. So if I'm defense, I want the first word, I want the last word, and I want to repeat my theme, my strategy, my defense as many times as possible. That's what people remember. The first thing they hear, the last thing they hear, and then the pattern that they heard throughout the trial. And so if I have anything and I'm Busby, I want the last word. I'm going to try to present evidence. But if Busby doesn't have anything, I think it just depends on his strategy. Like Marc said, if this is a no evidence case, if it's a no evidence argument that he's going to close with, then absolutely be dismissive, go straight to closing argument and say this is a nothing case. We don't need to show you anything because they haven't shown you anything.
And briefly, Tony, real quick, it's our golden rule of producing primacy and recency, the beginning and the end.
The bookend argument.
So speaking of the last word, Thomas, you have it. So,
I agree with everything they said. What I would add, though, is I doubt Busby's going to do that.
Yeah.
His style has been throughout this is to hit the political angles every chance he gets. Yeah. And if you'll notice, when they put Busby up, it tends to be the political angles. When it's Cogdale, he's the real deal criminal defense attorney that all of us have a ton of respect for. And that would be a really effective sort of lawyerly closing. But I don't think that's the way they're going to go. I think Busby's going to get up and he's going to make the political argument.
You guys were amazing. Thank you so much for taking your time, opening your brain, allowing us to learn from you as we all go through this. Just a few more days, it seems like, before this all comes to some sort of resolution, one way or the other. Marc, Chavez, Jorge Vela, Thomas Just, thank you again. And thank you again for watching. We hope you, too, have learned something from this conversation. And we'll be back tomorrow night at 6:30 for our legal roundtable. Hope to see you then.
Thank you, Tony.
Thank you.